Good morning, everyone, and welcome to the sixth virtual moot court competition conducted by Thomas George and Associates. I am Celeste Rose, and I will be the court marshal for today's session. I request all the participants to kindly keep their cameras switched on throughout the proceedings. In case of any technical difficulty, please inform us immediately through the chat box. This afternoon, we are honored to have with us our esteemed judge, Advocate Anuya Vaiserso ma'am. On behalf of the organizing committee and all participants, I extend a warm and respectful welcome. I will briefly introduce ma'am. Advocate Anuya Vaiserso ma'am graduated in BBA LLB from ICFI Law University, Hyderabad, with a specialization in cyber and criminal law. She is a legal professional with over 1.5 years of litigation experience at Thomas George and Associates. She regularly appears before various judicial and quasi-judicial bodies in various cities of the state of Telangana, handling a range of matters with professionalism and precision. She specializes in civil and matrimonial disputes, contributing to her well rounded understanding of litigation. She is committed to client focused advocacy and continuous learning. She aims to build a strong and impactful career in the field of litigation. Thank you, ma'am, for giving us your time today. If it may please the bench, I will now proceed to outline the rules for the round.
Yes, you may.
Each speaker shall be allotted 15 minutes, subject to an extension granted at the discretion of the judges. We humbly request the bench to keep the time frame in consideration. In event of an interruption caused due to internet connectivity or a technical issue, a maximum extension of 5 minutes may be permitted. The structure of the round shall be as follows. Speaker 1 and Speaker 2 for the petitioners will present their submission, and since this is an ex parte, we will not be having any rebuttals. A stable internet connection is required for all participants. Cameras must remain switched on for the duration of the round. Judgments or authorities may be screen shared if and only if prior permission is granted by the bench. With the leave of the bench, we are now ready to commence the session. May I request the first speaker to kindly inform the court how they wish to allocate their time?
As stated, we'll be allocating our timeline as this: 15 minutes for speaker one and 15 minutes for speaker two.
Okay. Uh, Whenever you are ready, speaker one, we can start the session.
And before that, I would like to confirm that my audio is stable.
Yes, your audio is stable. And I request all the participants to please keep their cameras on throughout the session.
Thank you. May it please the honorable court. The council seeks permission to address.
Yes, you may.
The council seeks permission to address the bench as your ladyship.
Yes, proceed.
Your ladyship, this is council number 1 from TGA 38, representing the appellants in the case of ABC Bank versus XYZ Limited. And your ladyship, I'll be dealing the first two issues of the moot proposition for 15 minutes, and my co-counsel, that speaker number 2, will be dealing with the issue 3rd and 4th for 15 minutes.
Yes.
The council seeks permission of your ladyship for a brief perusal of that.
Yes, you can proceed.
Much obliged. Your ladyship, we are a public sector scheduled bank which sanctioned 500 crores in credit facilities to XYZ Private Limited. Now, the debtor executed all loan documents and availed full loan amount. And initially, they repaid the amount regularly, but they later defaulted it, leading the loan amount being classified as a non-performing asset on 1st April 2014. Now, between 2014 to 2022, the debtor repeatedly acknowledged the liability by issuing multiple letters seeking restructuring as well as multiple letters for numerous one-time settlements. Now, the OTS was sanctioned on 1st February 2020, requiring the full payment on 31st March 2020. But the debtor again failed to repay, leading to the cancellation of OTS on 1st May 2020, which constituted a fresh as well as a continuing default. Now, the COVID-19 and subsequent amendment insertion of 10A of IBC came, and ABC Bank, we filed the first application based on Section 7 of IBC, mentioning the date of default as 1st May 2020 under the NCLT. But again, NCLT dismissed the same application, which is barred by Section 10A. And NCLAT also upheld the dismissal. But as earlier dismissal was procedural and not on merit, because multiple OTS letters extended the limitation, ABC Bank, we filed a second application under Section 7 on 1st January 2024, mentioning the original NTA date, that is 1st April 2014. And this is also supported by continuous acknowledgement by the defaulter. Now, NCLT dismissed the second petition on the grounds of res judicata, and also they have mentioned that we cannot change the date of default on our whim. Now, we are here before this honorable court under Section 62 for challenging these NCLT and NCLAT orders. If your ladyship is clear with the facts of the case, the council seeks permission to proceed with the issues.
Yes, proceed.
Much obliged. Your ladyship, there are two issues that will be dealt by me. That is whether or not a second application under Section 7 of IBC is barred by law, as well as whether or not mentioning dates of default is mandatory in applications of IBC. Moving on to the first issue, my ladyship, the council will be dealing with the first issue, that is whether or not second application is barred by law based on two major contentions. Firstly, the dismissal is without compliance to the mandatory proviso that is given under Section 7 plus 5B of IBC, as well as it was not based on merits that the dismissal was done by NCLT, and doesn't make any reference to the documents under Section 7(3) Clause 8. If I may elaborate on the issues further, the first contention, if I may read the Section 7 5B, 5B of IBC, it clearly states the adjudicating authority shall mandatorily give the debtor, give the creditor. Am I audible now? Is there any? Yes, sorry for that. There's a technical difficulty. Yeah, now yes. So, sorry for the technical difficulty, my ladyship. Ladyship, if I may read out again the Section 7B, it clearly states that
Yes, you may proceed.
Here, Section 5B says that if a default has not occurred on application under subsection 2, and or if any disciplinary proceeding is pending against it, the adjudicating authority shall give a notice to the applicant to rectify the defect in his application, which has not been complied with here by the adjudicating authority. And this is a mandatory proviso as it is evident from the statutory language. Again, if I may state two of the Supreme Court judgments, that is case Ashida versus Indian Overseas Bank, which clearly states that the procedural conformity to mandatory requirements is essential to confirm the finality of the judgment of adjudicating authority. Now, this has not been complied with, and thus this particular dismissal order by NCLT is without merit and without finality. Secondly, Supreme Court in Epic Bank also said that the finality emanates only from the orders which is rendered in accordance with the court. So, in accordance with the court, Section 7(5)(b), no notice has been served to the appellants to the petitioners there, and thus this particular uh, act by NCLT even infringes on our natural rights that of audio ultrampartum, and we are not being heard properly by the adjudicating authority. And secondly, your ladyship, under section 7 clause 3A of IBC, there are three major documents that should be submitted. Firstly, the record of default, and also the evidence of default, and the name of the interim RC, as well as any other info that is specified by the board. But the dismissal order of the NCLT has no any reference with these documents. It only stated about the date of default being not correct and coming under 10A of IBC. Thus, this particular dismissal order lacks finality, as well as it is not decided on merits. And no reference was based on the fact or the existence of default or the nature of default was made by the adjudicating authority. Now, this also infringes our right of speaking order. That is, the speaking order, which is also a natural right. So, we as appellants have been, the adjudicating authority has infringed two of our natural rights as well as statutory rights under IBC, section 5B as well as 3A. Sorry for that, my ladyship. And thus, this particular application lacks finality, and subsequently, res judicata principles cannot be applied. Your ladyship knows this better than me that res judicata can only be applied only if the first application has finality, and that is not the case here. Now, also, there is no explicit mention that there is second application under 7B can be second application from the section 7B can be made or cannot be made. So, as the statutory provision clearly doesn't have any mention that there is no section 7B application section 7B application be filed again, as well as our rights are being infringed on. Also, the national law principles are infringed. Therefore, it is humbly submitted before the court that there is no bar in the second application under section 7B of IBC. If my lordship is satisfied with the first contention, the first two contention of issue 2, issue 1, the council would like to move on to issue 2. Much obliged. My ladyship, the second issue is concerning whether there is a mandatory requirement to mention the date of default in the application. My ladyship, I will be dealing with that through three major contentions. The first contention is that there is no statutory requirement other than the section 7(5)(a) documents and evidences that I've already been read out. That is the document of default, the evidence of default, the name of RB, as well as any other info. There is nothing regarding the date of default being mentioned as a mandatory requirement to be mentioned in the application. Firstly. And secondly, the mandate of the date of default comes from Form 1 Part 4 of the Rule of IBC 2016. Only there it is mentioned that date of default should be mentioned. And again, if I may take you my is that disturbing my lady? Much obliged. Now, if I may take you to Vijay Kumar Singh versus Bank of Baroda, clearly stated that it cannot the NCLT or the adjudicating authority cannot override the substantive provisions of the code. And as well as in if I may take you to another decision by the Supreme Court, that Innovative Industries versus ITICI, it also says that if there is an existence of defaults and there are evidences, it should not be the Form 1 of Part 4 as a rule of IBC 2016 should not be a bar unless it is barred by the statute, that is IBC Code of 2016. as amended by 2020 again. So this rules doesn't have an overriding power over the statutory requirements, and as per the statutory requirements, we are not obliged to mention the date of default in the application. But at the same time, we have complied with all of the requirements and have submitted all of the documents, including the evidences that is stated under IBC, and these have not been made reference in the dismissal letter also. And my ladyship, I'll also submit that in the case of primal enterprises, it has been noted that there is a clear distinction between the date of default as well as the date of non-performing declaration of non-performing assets. Because the date of declaration of non-performing assets is only after 90 days of default. So even if we consider the date of default, that is 90 days before the declaration of non-performing declaration of assets as non-performing asset, that also doesn't come under 10A, which only starts from 25th March 2020 and only extends to 6 months. Therefore, nowhere this particular application date of default is barred by 10A. Therefore, the reasoning even given by the adjudicating authority also is not on merits. So, ladyship, if I may take you to one more decision.
Yes, you may proceed.
So, ladyship, in the case of REC Limited versus Hiranmai Energy Limited, it has been mentioned that even if a part remains unpaid on the due of date of payment, it considered default. So clearly, the date of default was the second one that is mentioned. That is the 1st April 2014. And we have also furnished all the details and evidences regarding the same. Now, here in the same case, it has been mentioned by the Honorable Supreme Court that the date, if the debtor is defaulting, even the repayment as well as the repayment based on the restructuring plan, it cannot, they cannot escape from the clutches of IBC based on Section 10A. Therefore, the reasoning behind the dismissal order was erroneous. And again, if I may take you to one more case, so that is Varanium Cloud Limited versus Salter Private Limited. The date of it has been said that date of default cannot be changed at whims and fancies of the petitioner, but again, this was again based on one more proviso that some if some of the financial debt is already, it's only when some of the financial debt is already been finally decided. That should be noted that it should the date of default cannot be changed only if this first petition is dismissed off with finality. As the council already argued in the first contention, the order was not final. So therefore, the council would like to submit that the second application is possible under section 7 of IBC. It is not clearly. It is not. The council would seek permission of 30 more seconds, dear ladies, to conclude the argument. Much obliged. The council would like to submit that the second application is completely permissible under section 7 of IBC, as the dismissal order was erroneous. Our natural right of odial from partem as well as the speaking order was violated, and it is not in compliance with the section 7(5)(b) as well as section 7(3)(a) of IBC, as well as there is no mandate under the IBC for mentioning the date of default. And even if we consider the date of default, it is much before the section 10A mandate of 25th March 2020. With this, the council would like to rest with the case if my ladyship doesn't have any questions. Much obliged, your ladyship. The council would like to invite the speaker 2 for dealing with issue 2 and 3 and 4, if my ladyship agrees.
Yes.
Much obliged, your ladyship.
May it please this Honorable Court.
I appear on the behalf of the appellant, ABC Bank, and I will be respectfully, Your Ladyship, I'll be respectfully addressing the issues 3 and 4. On issue 3 is on whether the date of default is flexible, and issue 4 is on whether a second petition, whether a second Section 7 petition is maintainable. So, moving on with the third issue, Your Ladyship, whether date of default is rigid or can change based on circumstances. Your Ladyship, our respectful submission is that the date of default is not frozen forever, and it can change when supported by factual developments and legal acknowledgements. The Insolvency Code nowhere mandates a single irreversible date of default. Section 7 speaks only the existence of default, and Section 3, Clause 12 defines default simply as non-payment when due. The code wants to see whether the debt exists and whether default exists. So not whether the creditor should be particularly mandated only to one date written in a form. So this position was made clear in the case of Innovative Industries versus ICICI Bank, 2017, Your Ladyship, where the Supreme Court held that once debt and default are established, admissions should follow. Substance must prevail over the technicality of dates. Similarly, in the case of Vijay Kumar Singhania versus Bank of Baroda, which Speaker 1 have also mentioned, the NCLAT clarified that forms and procedural details cannot override substantiative rights created under this code, Your Ladyship. Therefore, mentioning a particular date in Form 1 is a procedural requirement, not barring or preventing later correction when supported by evidence, Your Ladyship. Moreover, Your Ladyship, when we examine the limitation under Section 238A, we see that acknowledgement revive limitations through Section 18 of the Limitation Act, Your Ladyship. The principle has been cemented in three consecutive judgments, Your Ladyship. The first one is Dina Bank versus Shivakumar Reddy, which was on 2021. Next was Asset Reconstruction versus Vishal Jaiwal, which was also on 2021. And finally, Lakshmi Path Surana case, which was on 2020, Your Ladyship. All these three cases hold that balance sheets, OTS proposals, and written acknowledgement extend limitation and give rise to fresh cause of action, Your Ladyship. In our case, the OTS letters were issued continuously from 2017 up to 2022, Your Ladyship, each one being a fresh admission of liability. Therefore, default is not a static every acknowledgement pushes limitation forward, Your Ladyship, meaning the default date legally remains alive and actionable. Further, Your Ladyship, banking default is not a one-day event, Your Ladyship. It is a continuing default until the debt is repaid. The Supreme Court in Veer Gurjar Aluminium Mrs. Babilal recognized this continuing nature, Your Ladyship. The NCLT in Hindustan Construction Company, the case which was decided on 2023, it was held that in continuous transactions, creditors may rely on later default dates, Your Ladyship. Therefore, once default occurs in 2014 and continues without cure, the creditor is legally entitled to rely on later acknowledgement based default date, Your Ladyship. And thus, our application, which is filed on 2014, stands squarely within the limitation, Your Ladyship. Hence, for issue 3, I submit that that the date of default is not rigid and may shift when acknowledgement revive limitation, Your Ladyship, making our Section 7 petition maintainable, Your Ladyship. If Your Ladyship is satisfied and does not have any question, I would kindly move on to the issue 4, Your Ladyship.
Yes, you may proceed.
Much obliged, Your Ladyship. Issue 4, the issue 4 is based on whether a second Section 7 petition is maintainable, Your Ladyship. Your Ladyship, coming to issue 4, the maintainability of the second application. From our side, it is respectfully should be considered, Your Ladyship. The second petition is perfectly maintainable because the first dismissal was not on merit and was passed without complying with the mandatory procedures under Section 7B, Your Ladyship. Section 7B clearly states that before rejecting an application, the adjudicating authority must grant the financial creditor an opportunity to rectify the defects within 7 days, Your Ladyship. This was never done, Your Ladyship. Non-compliance with statutory mandates make the earlier order judicially defective, Your Ladyship, and such an order cannot attain finality or, as mentioned by Speaker 1, trigger res judicata, Your Ladyship. The interpretation is supported by case Sasidhar versus IOB of 2019, Your Ladyship, where the Supreme Court held that orders must strictly follow the court's procedural framework, for failing which they lack jurisdiction, Your Ladyship. Similarly, in an international case of IBIC Singapore Private Limited 2020 for a persuasive value, Your Ladyship, it was highlighted that finality exists only to orders passed after due statutory compliance and not otherwise, Your Ladyship. So even otherwise, the cause of action itself is different now, Your Ladyship, because the first application was based on the COVID period default, Your Ladyship, which was on 1/5/2020 and fell within the section 10A and was rejected, Your Ladyship. But then the second petition realized differently. It legally revived and default date is going to 1/4 of 2014, for which in the issue 3 I have addressed that it is a continuing process, Your Ladyship. It is not a single date of default. So supported by these multiple acknowledgements. So when the factual basis for limitation changes, Your Ladyship, res judicata cannot bar a fresh proceeding, Your Ladyship, because the issue is not same in the basis, your ladyship. Combining the rulings of the Dina Bank and the Bishal Jaiswal case, reinforcing that acknowledgement triggers a fresh limitation cycle, enabling a reinitiation under the section 7, your ladyship. Additionally, the objective of the IBC is resolution, not procedural dismissal, Your Ladyship, because at the end of the day, a debt is a debt and it is being borrowed, and we should address the issue of whether it is being returned, whether the debt is being paid back, Your Ladyship. That should be the main focus. So, in the case of innovative industry, it also reminds us that once debt and default are undisputed, admission must generally follow, Your Ladyship. And these excuses of the date not being mandated properly is it is not a valid ground um, to 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 negate the debit that has been borrowed, Your Ladyship. Even in Shivakumar Reddy case of 2021, it was further held that documents and pleading may be supplemented before the final disposal, Your Ladyship. So, which means all these we have time to change the date till the final disposal of all the documents, Your Ladyship. And even the 7 days, as mentioned earlier, the 7 days trial or the 7 days extension to change these defaults were also not given to us, Your Ladyship. So, hence, when a debt is alive, admitted, acknowledged repeatedly by the debtor, a fresh petition cannot be thrown out on technical formalities, Your Ladyship. Therefore, for issue 4, I humbly submit that the second section under section 7 petition application is fully maintainable, Your Ladyship, because the earlier dismissal lacked statutory compliance and did not decide on merit, and the present case is based on fresh limitation extended default, Your Ladyship. Uh, Your Ladyship, if Your Ladyship does not have any questions, can I move to the prayer?
Yes, you may proceed.
Much obliged, Your Ladyship. Wherefore, in the lights of the facts and circumstances of the present case, the arguments advanced and the authorities cited, it is most humbly prayed before this honorable court that it may be pleased to hold that the second application under section 7 of the Insolvency and Bankruptcy Code is not barred by law, as the earlier dismissal suffered from a jurisdictional defect owing to non-compliance with the mandatory provisions to section 7(5) clause B, and therefore cannot operate as a res judicata. Declare that mentioning a specific date of default in Form 1 It's a procedural requirement, not a mandatory substantive condition, and that the maintainability of a Section 7 application depends on the existence of debt and default and not on the immutability of any particular default date mentioned in the form. Hold that the date of default is not rigid or confined to the NPA classification date, and that the financial creditor is legally entitled to rely on different or subsequent date of default based on acknowledgements under Section 18 of the Limitation Act and the continuing nature of the default. Direct that the current Section 7 application must be admitted as a default has unquestionably occurred, and the application is well within limitation by virtue of continuing acknowledgements that any earlier inadvertent error in stating the date of default cannot defeat the substantiative right to initiate the CIRP and or pass any other order that this honorable court may deem fit and please to grant in the interest of justice, equity, and good conscience. For this, the petitioner shall humbly pray your lordship, your ladyship.
Does the ladyship have any questions for either of the councils?
No, you both have performed very well.
Thank you, councils.
Thank you.
With that,
Thank you.
we have reached the conclusion of the pleadings for this round. On behalf of Thomas George and Associates and the organizing committee of this moot, I would like to express our sincere gratitude to your ladyship for presiding over this session. We deeply appreciate the time, patience that you have shared with the participants today. We also extend our appreciation to all the participants for their effort, preparation, and decorum throughout the proceedings. If it may please the bench, this round now stands adjourned. Thank you, everyone. Have a wonderful day.
Thank you.